Still sharing the right one?
We're good, yes. Hello, everyone. We're just going to wait a few minutes as everyone joins us today. Come on in, find a seat, make yourself comfy. So as you guys are coming in today, just please introduce yourselves by putting your name, organization, and where you're from in the chat box. And you can share that with everyone. Welcome, everyone. Thank you so much for joining our webinar today. Please note that we are recording today's session. Before we get started, we ask that you introduce yourselves in the chat box. Please add your name, organization, and where you're from. My name is Guylaine Green, and I am the new Chief Administrative Officer for SARP. With me today is Nicole Clow, our Program Manager. I would like to thank Nicole for setting up this educational opportunity. The timing is perfect, as most restrictions will be lifted and recreational facilities and programs will start to look normal again. It's the perfect time to talk about waivers and liability. Before we introduce our guest speakers, we have some reminders for you today. A Zoom webinar is a view-only platform where you cannot see one another. This includes the unavailability of your mics. We know you will have questions throughout the session, so please type them in the chat box and we'll get to them at the end. Our guest speakers today are Aron Bookman and Megan McNeil. Aron and Megan will review questions such as, what is a waiver, release, and indemnity as opposed to an informed consent? What do all of the clauses mean? Are they worth the paper that they're written on? If you've ever had these questions, be prepared to have them answered. They will use real cases and examples to help better understand if your waiver, release, or indemnity is protecting your organization. Aron, the floor is yours.
Thank you. So folks, this presentation is fairly lengthy, so I'm going to kind of dive right into it. We have a lot of slides here. As you may know, my firm, Carfer Lawton LLP, is based in balmy Victoria. I think we're 40 degrees Celsius today. We act for institutional clients. One of my main clients is the MIABC, which is the insurer for most municipalities in British Columbia. So I do a lot of work in the area of municipalities, regional districts, and all kinds of types of personal injury claims. Also do a lot of work in the area of waivers and informed consents for private insurers, for all kinds of venture activities and things of that nature. And I handle the claims, unfortunately, that do arise where someone's badly injured in a venture activity or on a municipal or district property involving adventure activities. So I come from a place spiritually of very much in favor of outdoor activity. I am a hiker. I like to backpack. I like to canoe, kayak, paddleboard, you name it. And the reason that you folks know me is because I was introduced to you folks by a fellow board member on the Child Nature Alliance for Canada board. And so that organization, as you know, is an advocate for children and play. And so that's where I come from. And the picture on this first screen is one of my kids climbing a tree. So that's where I come from. I believe in risk and play. I don't like that the litigation structure will detract from those opportunities for us and for our kids. And so I try to do my best to help folks understand what the legal parameters are as they pertain to these activities. Oops, there we go. And you know, one of the things that this slide is interesting. So on CNAC, the Child Nature Alliance, at one point, one of the big things for CNAC is use of fire with kids, right? So at the Forest School in Ottawa, They had a big fire pit every day because it's cold, and all the forest schools, et cetera. And they teach teachers and facilitators how to use fire safely with kids. And so they at one point wanted to have matchbooks to give out as a token of your participation in our programs. And when they ordered them from the United States, they had this warning on them. And so you have a picture here of a kid with a match, and it says, keep away from children. So that was the ridiculous part of this process that they encountered. And we learned there was actually some legislation in the United States that required that warning on the matchbooks, which seems rather ironic given that you can see the pictures here of what's involved. So the point here is that this idea of warnings have gone a little bit too far. That you can see here, this is the Grand Canyon. They put up a rope and they put up a sign and people walk right over it or around it to the edge of the canyon. We have to have people take responsibility for themselves. Unfortunately, when things happen, they try to blame others. And that's the reality that I live in as a lawyer. So as Guillaume was saying, we're going to go through some topics today. We're going to go through what is a waiver, release, and indemnity. What do these clauses mean? And, you know, every time that I'm out, not every time, but I'm often out with people and they say, it's not what the paper it's written on. You'll hear people go and sign something, make a joking statement about, I'm signing this waiver. It doesn't mean anything. Well, it does. And I'll show you why. It means quite a lot. And there's a distinction between adults and signing waivers and between your children and the children in your programs and whether they can waive or release their rights. But it is worth the paper it's written on, if not much more. And the last piece is informed consent model. And I'm going to explain to you why I advocate for this, particularly for municipalities and regional districts, that in my view, the informed consent model, given that you have a lot of children involved in your programs, and you may not feel right about having a waiver in your programs, given you're a public service organization. And there's an informed consent model that I think strikes a good balance. So those of you who may have knowledge of this area of law may know about a case called Thompson versus District of Saanich. And in the Thompson case, young Miss Thompson, I think was 11 or 12, and she was at an art drama camp hosted by the District of Saanich, which is where I live. And they're hosting this at a middle school in Saanich as well. And they were out at their recess time, as kids do. And Miss Thompson was playing a game called Grounders, which is a game of tag, basically, with some variants to it. And she fell backwards, my pointer here, from this area of the playground equipment onto either this post or that post and struck her head and suffered a head injury. And so she sued. And one of the issues raised in the lawsuit, there was no waiver in place. Basically, all the folks did was sign up for the program, and they informed Saanich of what any health issues their kids would have had. One of the arguments made by the mother in the case was, you should have let me know that the kids were going to play Grounders. If I would have known they were going to play Grounders, I would have told my children not to play. And therefore, you failed to warn me of this issue with Grounders. And that's the informed consent issue I said a moment ago. And you're responsible in negligence for not having warned me of this dangerous activity. This is a long quote, but it's helpful because it's important to know that there's no warning required as a matter of law unless the risk of harm is unreasonable. So that's what you have to think about. Is there a risk of harm here that I should be thinking about that's foreseeable in the context of our programs that's something out of the ordinary that I should warn about? If someone walks into a pool facility, you don't have to have them sign a waiver about slipping and falling on the pool deck, because that's something that's not unknown. Everyone knows about that risk. It's where you go into the area of something that's a little unusual, you got to think about whether or not there's some reason to warn, and then if so, is there a reason to have informed consent or reason to have a waiver? And most of what you folks do, I suspect, does not involve this. But if you're running particular activities, I don't know, skateboard camps, mountain biking camps, rock climbing, things like that, now you're in a little bit of a different area. So this is just a long quote here about the Grounders game. You can see the judge rejected the argument that this warning was required, just basically saying it's just like a game of tag. And the next case I'm going to go to is called Duddle versus Vernon. Again, on this theme of what needs to be included in an informed consent or a warning. The point being, not everything. I think these waivers and informed consents are most useful where they're not used all the time. So this is the Duddle case, and this is a peer in Penticton, or it was Vernon, sorry. And Mr. Duddle, the evidence was familiar with this pier. You see all the warning signs on this pier, but not diving off all over the place. And of course, he dives off and he breaks his neck. And the lower court in our courts, that's the Supreme Court of British Columbia, made a finding that there was negligence because essentially the judge went through all this evidence and said they didn't do all they could have done to inform Mr. Duddle of this risk. And the case is fairly long, but if you want to read it, I think it's very helpful to read. The lower court judge was, I suspect, sympathetic to the claim, and the judge basically got the test wrong. There was no waiver involved, of course. You're not going to have a waiver as folks walk into a park like this before they want to go use the pier. But the point is that the Court of Appeal said, no, this was a danger he should have been aware of already. There's no need for a warning. There's no need for any type of informed consent, no need for a waiver. This is just his own fault. So I'm going to lead you now into some law that Megan's going to go over in Saskatchewan. Megan is one of our students here at our firm. We are not Saskatchewan lawyers. So when it comes to Saskatchewan, we're not licensed in Saskatchewan. We can't give advice on Saskatchewan law, but we did do a little bit of research to better inform ourselves of what the law may be in Saskatchewan, how it may differ. So Megan, go ahead and go through some of the Saskatchewan law you found.
Thank you, Aaron. So this is a recent case from this year in Saskatchewan called Abbott and Saskatchewan Power Corp. So in this case, Mr. Abbott was snowmobiling in the ditch along a highway near Meadow Lake. He was participating in a snowmobile derby that was organized by the Recreation Board. He was snowmobiling outside of the marked route and outside of the designated trails in the area. You can move on to the next slide, Aaron. So unfortunately, Mr. Abbott collided with a power pole guy wire and died. So this guy wire was attached to a Sask power pole. And you can see it's the diagonal wire coming from the pole there that he collided with. And the next slide. So the plaintiffs, Mr. Abbott's wife and Mr. Abbott's estate, alleged that Sask Power was liable in negligence for Mr. Abbott's death. Sask Power acknowledged that they owed a duty of care to Mr. Abbott because Sask Power was aware that snowmobilers often operated their machines in the area. However, their duty of care was limited by Saskatchewan's Snowmobile Act, which has a similar wording to British Columbia's Occupiers Liability Act. So it had sort of a similar effect in limiting liability. So pursuant to the Snowmobile Act, Sask Power would only be liable if it was proven to have done a willful act with reckless disregard of the presence of Mr. Abbott, a snowmobiler foreseeably operating a snowmobile in the area. So the court wrote that a willful act requires intention and action. So even if Sask Power had failed to inspect or maintain the power poles, this failure would not constitute a willful act pursuant to the Snowmobile Act. So the court held that there was no evidence that Sask Power acted with reckless disregard of a snowmobiler or of Mr. Abbott. So they determined on a summary judgment that the plaintiffs failed to prove that Sask Power was liable in negligence, and they dismissed the plaintiff's claim.
So the reason that that's helpful is because in British Columbia, the Occupiers Liability Act, and I think Saskatchewan is the only province without a similar piece of legislation. I did a presentation over a year ago where we kind of went through that in some detail. And as Megan pointed out, under our Occupiers Liability Act, when it comes to recreational trails, like this one would be, there is a reckless disregard standard versus an occupier's negligence standard for the standard of care. And this particular legislation clearly was put in place to ensure that there was a similar higher standard of care in Saskatchewan for that type of activity. Or activities that would involve their lines, so to speak. So I think that's an important issue here. But For you folks, one of the issues we have is that the Occupiers Liability Act in BC is, I would suggest, a bit less onerous than the common law as it pertains to what the standard of care is for invitees that come into your facilities. So when it comes to your invitees in your facilities, then you are at this higher than reckless disregard standard of care that is analogous to the BC standard of care, but again, it can be unpredictable. And we've gone through this in a bit more detail here. This is a slide that we cut and pasted from the previous presentation I did for this group, dealing with facility use agreements that I was dealing with in that presentation. And so you can see here, this invitee standard is reasonable in the circumstances. And I put this out there because, again, we're not Saskatchewan lawyers, and there is I'm a bit less certain of how the courts in Saskatchewan will deal with the invitee standard versus how we deal with it here in British Columbia. So that all is the idea of what is the standard of care. We know negligence requires a duty of care. As Megan pointed out in the case she showed you called Abbott, the defendant admitted they had a duty of care. And you folks, as the persons running facilities or programs, et cetera, will owe duties of care depending on what the activity is and where it's taking place. If you have persons taking kids in a summer camp to a park that's not operated by your municipality or regional district, there may be an occupier's duty of care owed by the persons who own that park, whereas you folks may just have the duty of care of a reasonably prudent parent. If you are doing some activity that's particularly risky, which we'll go through in a moment, you may want to consider what agreements to put in place, particularly for adults, that would deal with those potential duties of care. So the waiver or release is designed to prevent a person from suing. Anyone can sue anyone for anything. So you can't stop them from filing a lawsuit. But the question is what happens after they've filed a lawsuit? And obviously, these agreements are deterrents for filing lawsuits, because a lawyer will know this could be a more challenging lawsuit than I would anticipate if it just involved no waiver or no release or no informed consent. Now, the infants, I'll show you in a moment, a parent can't waive his or her children's rights, at least in British Columbia. I doubt it can happen anywhere in Canada, but at least in British Columbia, the law on this is clear. And I'll show you that in a moment. So for infant participants, there's been this workaround that is included in most of these agreements that's called an indemnity. An indemnity is what your insurance provides. So if you drive a car, which most of us do, the insurer indemnifies you for what occurs in a motor vehicle accident. Of course, that's all changing in British Columbia because of our no-fault stuff. But in any event, that's the theory behind insurance. If someone's at your house and they trip over some hazard in your house, your homeowner's policy indemnifies you for the claim. So what these indemnities do, and if you ever take your kid to a trampoline park or something like that, and you read the agreement carefully, you'll see the word indemnity. And what this is supposed to do is put you as the parent in the shoes of the insurer for the facility, which no one really knows except for us lawyers. And that can be pretty onerous, and it's never been enforced. I'll show that in a moment, but it's something that I want to highlight because it's a workaround from the fact that you can't have a kid release his or her rights. The last point, and I'll show this as well, even if the person posting activity is negligent, these waivers will be effective. The indemnity maybe not, but the waiver certainly can be. So the first thesis for our discussion today is it ethical to require adult participants in adventure tourism? I'm not talking about municipalities or regional districts. I'm talking about adventure tourism. But also, what about recreational users of facilities to waive their rights? Is that ethical? And it may be different depending on who you are and what you're doing. So Loychuk is the key case in British Columbia and is also cited all over Canada for this concept. And I'll let you read it. This word unconscionable is the key word. And the Supreme Court of Canada and Turcom Contractors basically said, courts have a public policy overriding authority to not enforce certain contracts. And I'll show you that in a moment as well. And what Loychuk says is this concept of trading participation in this type of, this case, a zip line, with waiving your rights, even in negligence, is a fair trade. It's something that our court in British Columbia said they don't find to be unconscionable. Doesn't mean they don't, doesn't mean they support it, doesn't mean they advocate for it. It just says that they will enforce it. And our Occupiers Liability Act, which of course you don't have, has something similar in it, where it says in the section 4 that a person can restrict or exclude the duty of care as long as the person takes reasonable steps to bring it to the attention of the person who's signing the agreement. And this has been litigated a bit as well. This standard is codifying the common law standard. So when you look at waivers and releases, particularly in Saskatchewan, you'll see a lot of law about reasonable steps to bring it to the person's attention and disputes about whether that was done. In the UK, these agreements are prohibited. And I raise this because in my debates with my colleagues on the plaintiff side of this issue, and I have a number of friends on both sides of the bar, they point out that, hey, in the UK, they prohibited these types of the agreements. Why can't they do it here? And that's a fair point. But so far, the legislatures in our provinces have not taken up this task, nor has the federal government. And the context here, of course, is that I don't know what you folks do, but I know in Ontario, like this picture here, and British Columbia, municipalities are taking on more risks. I think we have a period of perhaps time, municipalities are realizing that they provide a lot of recreational support and activities for kids and adults alike. And if they don't do it, nobody else will. So you have pump parks like this one. And you have even more challenging things like this type of element in a park in Bruce County in Ontario, which is subject to the case in a moment. And this, if you're a mountain biker, these are different elements. This is the easier element. This is the harder element. And guess what happens? Mr. Campbell breaks his neck. And so this is a Campbell versus Bruce County case. Now there's no waivers involved in this case, but you can see how when you look at this case, even in here in this line I've underlined and bolded here, they distinguished the Duddle case with the fellow jumping off the dock with this case. And they said the warning here wasn't sufficient to warn Mr. Campbell the risk of injury or death when he fell off and used this teeter-totter up here, okay? I'm just showing this because it's concerning. You have courts in two different provinces having very different perspectives, I suggest, on how the law works. And that's part of what we grapple with here in British Columbia when we try to look elsewhere for law. BC is actually, in my view, the most waiver release friendly province in the country. Other countries are not as friendly towards this type of weighing of risks. So what's the meaning of this term, waiver release? A waiver or release gives up a right, and it's just like if you, and you folks probably have done settlement agreements, if someone's hurt and they sue the facility or municipality for that, before there's a trial or any type of adjudication, that person can release the municipality or district from that claim. It can happen even before lawsuits commence. And so that's the concept I want to draw your attention to. That even before there's a judgment, we all know that there can be a release agreement. And what we're doing here is that you're doing a waiver or release before you even have an incident. And that's the difference here. Before the incident even occurs, you're saying, I'm waiving any rights I may have from that activity. And I showed you Loychuk, and so in BC, the law is quite clear. Adults can waive their rights. And as I said earlier, you can't stop the lawsuit from starting, But once the lawsuit starts, the question is what happens next? And every province, to my knowledge, has a form of a summary trial or summary judgment rule, whereby you go to trial on affidavit evidence alone. And so in BC, the process has been start your case, go through written discovery, and then oral discovery, assuming the person is still living. And then you have a summary trial application about whether or not the release is enforceable, or the waiver, I'm sorry, is enforceable. And so you can imagine that's a much more efficient process for defendants than a full trial. And so in BC, that's been successful. In other provinces, and we've noted case law from Alberta, Nova Scotia, and Ontario, it seems the courts are saying we want to have a full trial, whether the person understood the waiver, basically. Whereas BC courts say it doesn't matter if they understood the waiver. The waiver is clear on its face. You have other courts saying, well, we want to make sure we have all the evidence in front of us. And unfortunately, what that means is likely those cases settle. So here's Cougar Mountain zip line. I'm just showing you, this is Loychuk. So this is a zip line at issue in Loychuk. This is in Whistler. It's one of the longest zip lines in the world. And it's so long that you can't see from one end to the other. So they have to radio to say, hey, it's clear now to send the next person down. It takes over almost 2 minutes, I think, to get down the zip line. So they had the perfect case. They had a fitness instructor was injured when the zip line guide sent her down, or sent the law school grad down before she was out of the way. And the evidence was clear that the law school student had some knowledge. The fitness instructor used waivers in her personal fitness company's processes. So she knew what a waiver was. And so they had this kind of perfect case to run this on. So on summary trial, the Supreme Court judge dismissed the case. And I showed you the appeal court agreed. The Supreme Court of Canada did not grant leave for appeal, which is an indication that the Supreme Court of Canada was not interested in hearing argument on whether this type of procedure was the right way to deal with this type of agreement. Now, I think that the Supreme Court of Canada decision may be brewing on this, because I think you're having two lines of decisions being created in BC versus Ontario in particular. The Supreme Court of Canada may be asked in Ontario, I suggest, to take up a case that is not dismissed on summary trial. And here's the example. You have almost identical type of circumstance. Here's an Ontario case on a zip line in Alaska. This is on a cruise ship excursion, where the plaintiff breaks her femur when she basically hits the tree. And so they said, of course, this was negligent, and there was difficulty with the brake system, and you should have known, and you shouldn't have done this. And it's probably true. There was negligence, but there's a waiver in place, and she had signed this document. And here's what this one looks like, which is not as long, but pretty long. And I've done probably 40 zip lines through various places I've been over the years. Pretty typical zip line, pretty typical system. And so in Ontario, the Supreme Court judge, or Superior Court, sorry, says you got to go to a full trial. We need to hold a full context of the agreement to fairly and justly interpret the agreement, to deal with the validity, et cetera. And I juxtapose these cases for a very clear reason. You can see how different it can be province to province about what happens with a waiver. It's quite remarkable that in Ontario, they're not adopting the same procedure as Loychuk. If you know the procedural law as it pertains to superior courts and Supreme Courts and what's called summary trial or summary judgment in the two different provinces. And I do have enough knowledge of that to know that there's no real reason for the courts to have a different view of this, but the Ontario courts have taken this view. And to just give you another example of BC and Ontario, So this is the Jameson case in the Whistler Mountain Resort. It's a mountain biking case, just like you had in the Bruce case. And this fellow's a paraplegic, unfortunately, because he took this very difficult A-line rock drop feature and broke his neck. And so you have a very experienced skier and worked at Parks as a volunteer, ridden the course before. Here's the feature, which I looked up on YouTube. It was described as a pretty hairy feature with lots of accidents on it. And mountain biking is, as you know, pretty risky. And people my age think they can do it like people who are 20. And sometimes things happen. So I point to juxtaposing the Jameson case with the Campbell case is to just show you that in the Jameson case, it was dismissed, but of course, in the other case, it wasn't. So here it is. I talk about signs and forms. In the Jameson case, this form was found to bind the plaintiff, in the case dismissed at summary trial. And they made an argument that release must warn of the specific risk of spinal injury or being thrown off the handlebars. That didn't succeed. So that the plaintiff lawyers said, hey, this release wasn't particular enough. It needed more verbiage, needed more clarity. And this comes up frequently, and I think it's gonna come up for me in a case in a few years from now, depending on how the case goes. The idea that if the waiver doesn't say particularly what happened, it shouldn't be enforced. And Justice Adair in this case said, no. The release was clear and blunt, and the signs reinforced all these warnings. So go ahead, Megan. We found one case, I believe, in Saskatchewan, which is helpful here.
Yes, and this case dealt with the electronic form of waiver and release. So this one is Quillicini and Wilson's Greenhouse and Garden Center. So in this case, the plaintiff was injured go-kart racing at the facility owned by the defendants. And before he started go-karting, he signed an electronic waiver and release. So on the next slide, I have the release that he signed there. And you can see at the bottom in bold, it says release. So he's expressly discharging the defendants from any claims, liabilities, demands, and actions for damages arising in any way from the plaintiff's participation. So at the time of the collision, the plaintiff claimed that the go-kart's throttle broke, causing him to crash into a concrete barrier. But the defendants claimed that the collision was the plaintiff's own fault and that the plaintiff's claim should be dismissed because the plaintiff had executed the electronic waiver and release before he started operating the go-kart. So an issue in this case was whether the electronic waiver and release was binding on the plaintiff. So you can go to the next slide there, Aron. So the court did consider cases from both Ontario as well as British Columbia Supreme Court and Court of Appeal. And the court held that the electronic form of waiver and release was binding on the plaintiff. He had full opportunity to read the waiver and release. And by clicking the I agree icon, he was creating a binding contract. So in this case, the Saskatchewan court found summary judgment was appropriate and dismissed the plaintiff's claim and held that the e-waiver released the defendant from all claims, including negligence.
So what Megan found indicates to me that Saskatchewan may be closer to BC on how it deals with these waivers. Now, I don't know enough. I didn't read that decision myself, but that's a good indicator that there, I think Loychuk was cited in that decision, and it's an indication that the Saskatchewan courts are more in line with the BC courts rather than the Ontario courts about using waivers and dismissing cases on summary judgment or summary trial, which means trial on paper versus a full trial, to resolve these types of disputes. So that's a good thing, I suggest. We have had a few cases that deal with waivers and the issue of public policy. But before I do, I'm gonna go back to the language here. So in other presentations, I had a slide where I went through a full agreement that's like this involving trampoline parks, but I wanted to save some time here, so I didn't include it. If you look at the wording here, there's some key wording here. You see the term assumption of risk. And this is where anyone who writes these documents, which I write a lot of them, says there are risks involved. So there's an informed consent model that is built into these documents. And what this means is if I operate the Velocity Raceway, I need to think about what those risks are, and I need to put those in this document to say, hey, you could actually be paralyzed, even die doing this activity. Now, what's the risk of death in a go-kart? Probably really low, but you put it there anyways. And this can be more complicated depending on what you're doing. River rafting, for example, trampoline parks, for example. You can name the examples, but you have to turn your mind to this. We do this assumption of risk part. And the release, this language is very familiar to you folks who have seen settlement agreements. It's very similar to what you have there. And so you can have various forms of this release. It can say release and waive. And the piece I didn't include here is the indemnity piece, which we can look at if you're curious to see, where there's another clause that says, and I indemnify you from anything that may happen from my participation, my child's participation in this activity. And that's the one that I've always found a bit hard to swallow as a parent when I go to a trampoline park, for example, that indemnity issue. I just find that a little rough to know, because I understand it. And the agreements will say things like, I've had a chance to consult a lawyer and things like that. Well, who does that? You know, when they're presented with an e-waiver, when they come into the trampoline park with their yelling, screaming kids want to jumping on the trampoline, who's going to read this thing from front to back and then call a lawyer and say, hey, if I sign this, what am I doing? No one does that. So there is this issue here, I suggest, as between adults who should read any contract and should understand it, and a parent, even with his or her children, who takes their kids to some place like a go-kart place, is asked to sign a document that purports to waive their kids' rights or purports to have them indemnify the place in case something goes sideways. Well, this is interesting too, because almost all companies now are using electronic waiver forms. And this is the only case I'm aware of that actually has dealt with it and enforced it. I think they're enforceable. I think they're no different from the other ones, in my personal opinion. But it's interesting that they actually went through that here. So getting back to the slide on public policy, just quickly, in BC in particular, they've said, we're going to enforce waivers with adults, but there will be some slim exceptions, and they're very slim exceptions. So in Niedermeyer, what had occurred was that it was a zip line, just like in Loychuk, but the person, they drove from the facility where you meet up to the zip line. I've done this zip line actually. And it was on the van or bus ride from the place where you get your gear on and stuff to the zip line. The fellow drove off the road and rolled the vehicle. And there was the release and waiver was quite broad. And it included the travel from that place to the actual location. The travel was on an actual road. It wasn't on a dirt road. And to a certain point, that is, where the guy went off the road. And the Court of Appeal said, no. We have a statutory regime of insurance in British Columbia, at least until May of this year, that includes liability up to $200,000 and more. You can't waive your way out of that. So of course, as a matter of public policy, the MBA claim could go forward. Similarly, in Ontario, there was a go-kart race waiver, and there was a race director employed by the raceway park who was basically smashed by a go-kart and thrown into the air. And they said, well, hold on, there's a waiver here, and we don't have to go to the WorkSafe, whatever. And it's kind of confusing, but basically what the Court of Appeal said in there was that you can't waive your way out of your obligations to an employee. And so that's what happened in that case. So go ahead, talk about apps, Megan.
Yes, so this is another example. It differs from Loychuk because here there's no signature involved. Instead, it's about sufficient notice of the waiver. So this is a photo of Grouse Mountain and the terrain park. And in this case, the 20-year-old plaintiff from Australia was attempting the XL jump in the terrain park, which might have been that one because it looks quite large. You can switch slides there, Aron. Unfortunately, he was rendered quadriplegic as a result of a spinal injury because he didn't land the jump. So in this case, as I said before, he didn't sign any waiver and release. The terms of the waiver were posted above the ticket booth and on the back of the lift ticket. So Grouse Mountain's waiver purported to exclude their duty of care under British Columbia's Occupiers Liability Act. But the plaintiff testified that he didn't read the waiver and release either on the ticket booth or on the back of his ticket. So he sued Grouse Mountain for damages and negligence and breach of contract, breach of the Occupiers Liability Act, and breach of the Business Practices and Consumer Protection Act. The plaintiff also alleged that Grouse Mountain was negligent in their design, construction, maintenance, and inspection of the XL jump. But Grouse Mountain denied the negligence and the breaches alleged and relied on the terms of the exclusion of the liability notice contained above the ticket booth. So the enforceability of the waiver depended on whether Grouse Mountain took sufficient steps to bring the waiver to the attention of the plaintiff. And the summary trial judge held that the waiver was incorporated into the transaction. So when he bought the ticket, he was agreeing to the waiver. And the summary trial judge considered the signs posted in the terrain park as part of that notice of waiver. However, the Court of Appeal set aside this decision primarily on the basis that Grouse Mountain provided insufficient notice to the plaintiff of the waiver. The terrain park signs did not constitute notice because the plaintiff had already purchased the lift ticket by the point that he was in the terrain park. So the court confirmed that the notice of waiver has to occur before the purchase or at the time of the purchase. It can't be afterwards in the terrain park.
So what you see there is a chink in the armor in British Columbia on this whole issue of waivers. And what occurred there is a particular lawyer who I know fairly well, who is the lawyer for most ski resorts in British Columbia. And of course, that individual, you can imagine, had drafted all kinds of waivers and warning signs, et cetera. And there was success on a number of ski cases, and like you saw the Jameson case, he argued that case, which is basically Whistler in the summer, right? So they had success with waivers for activities, and they tried to say, well, this is no different. When you have your lift ticket with and if you ever go to British Columbia, Whistler, Blackcomb, any place, you'll see the way the waivers look. They're the way the ones that I draft look, the way the ones other lawyers look. We all copied the same appearance. And those things we posted in big yellow letters, big black letters with yellow above where you buy everything. And the point there was, hey, it's all right here. Why must we include it now in some document you sign? So I think what may have to happen now, depending on how they're going to operate, they may decide to make adults start signing waivers now at the ski lifts. We'll see. Those aren't my clients, so I don't know what'll happen there. We can see how that case was argued, and that there is a bit of a, I said chink in the armor on this whole issue in BC. I think it's again just chink in the armor. I don't think it changes anything about the Loychuk case. So here you go about thesis one. The BC courts will enforce these waivers. The Act permits this. There's overriding public policy sometimes. And the question I pose, which we can discuss perhaps later, is what about local governments? Should you behave differently? And then the second thing, what about a parent or guardian? Should this indemnity be something that's required? And the case is called Wong versus Locke's Martial Arts. There is no case I'm aware of other than this case, a lower court decision in British Columbia, which says this very simple thing, which says that under the Infants Act, under common law, under any iteration of the law, a parent cannot waive his or her children's rights in a case such as this. There are ways that a parent can act as a litigation guardian, and they can waive rights in a lawsuit that's ongoing. There's all kinds of protections built into that under the Public Guardian Trustee Act in BC, probably something similar in Saskatchewan. But here you go. It's not permitted. So in this case, you had basically a user agreement type agreement, a handbook, I think it was, that the parents signed, included a waiver. The kid got hurt, the parents sued, and the court said, no, this waiver doesn't help you. But there's a problem here, because obviously you don't want the karate studio being sued every time a kid gets hurt, right? You want to have trampoline parks, I assume, most of us do, things like that, where there is risk. Kids may and do get hurt. So what do we do about that? And you have the reality that there must be insurance. How much will insurance cost? What will the insurers require? And, you know, as you can imagine, I work with insurance brokers, insurance companies, and also operators of facilities, and it all marries together. So these sophisticated insurers and brokers are requiring a waiver program to be in place to get insurance. And so they have this indemnity workaround of the issue of whether the waiver is enforceable with kids. And that's where I think the rubber is going to hit the road. Will that be enforceable? So I told you earlier, this is a contract agreement between two parties in which one party agrees to pay for potential losses caused by the other party. An insurance contract is a contract of indemnity. So if you took your kid to a trampoline park, and if your kid was hurt, and you decided, or your spouse decided, or you put a litigation in place to decide, we're going to sue over this injury. I've got a case like this right now. We're going to sue because my kid broke his or her leg at the trampoline park. If the indemnity is enforced, that means that the parent who signed the indemnity would have to step into the shoes of the insurer and defend the trampoline park company, et cetera, over what occurred. And if you know insurance law, you'll know that there's a prohibition in insurance policies that if you have a homeowner's policy, which many of us do, or a rental policy, you have a general liability policy as part of the policy you purchase, but it doesn't apply to claims made by your own children or children living in your own household. So there'd be no insurance for you as pertains to this type of claim. So you'd be uninsured trying to defend this type of claim if it works. So you can imagine this deterrent that could exist to a parent suing a trampoline park, for example, over an injury at the park, even if they think the trampoline park did a poor job supervising or whatever, right? This issue was dealt with in 1994 on this report on recreational injuries in British Columbia. This is a British Columbia Law Commission report, or actually no, it's the Federal Law Commission. And the Federal Law Commission dealt with this in 1994. The Harper government got rid of this law commission, but in 1994, this issue came up and they said, look, you're going to have indemnities in these agreements because of the Wong decision and because of the reality that the parents can't waive their kids' rights. And the Law Commission warned about this, yet no one did anything about it. And anyone who's been to one of these places has signed the agreement and said, well, it has an indemnity. I don't know what it means, but I'm going to sign it. I know what it means, so that's always hard for me to sign. My wife often signs those agreements, but she knows what it means too. So what's going to happen with indemnities? And there's no law, there's no case enforcing these indemnities. And I've got an application right now, one of my cases about these indemnities that we're trying to decide what to do with. But the point is that it's intended to have the same impact or effect as a waiver. The question is it going to be something that is void as a matter of public policy? I have not seen this argued, although it may be argued in the case I'm handling now, to apply the Niedermeyer case and the other case I showed you to the indemnity and say, why should, I'll just use again the trampoline park operator, work around the Wong case, the Infants Act, with an indemnity? Why should they have this workaround? Shouldn't the courts find it's not enforceable to boys as a matter of public policy? No one has taken this to court on either side of it. My experience has been it's more likely the infant claim will be settled than an adult claim resulting from a place like a zip line park or a zip line or trampoline park or whatever. But these issues are brewing. And at some point they will be litigated in the right case. I haven't had one yet. We'll see if I do. And I wonder what will happen in that regard. So that leads me to informed consent. A parent can consent to medical treatment for an infant. And generally, this type of agreement is something to allow something to happen after all relevant facts are disclosed. So what's the purpose? Inform the participant of the risk, or the parent or guardian. We saw Thompson, who said, I would have liked to know the kids were playing grounded. So the court said that's too much. But you can imagine other activities where a parent would like to know a bit about what the child's going to be doing. You can imagine, for example, if it's a camp that's in the outdoors, hey, parents, we're going to have the kids start their own fires. We're going to have the kids sleep outside without a tent, things like that. The parents should know, or should at least be informed of this, and not find out later about some of the risks that they didn't anticipate. And the important thing is now you've defined the risks. And of course, the tension point is how many risks to define. So I was going to show you, and I'm just going to stop sharing my screen for a minute. I'm going to put up another document. And let's see. All right. So you should have an assumption of risk form on your screen. This is one that we crafted at the Child Nature Alliance of Canada for use in the forest school programs that used to be operated through the CNAC and operated through a private company. But you can see here, this is a form that I've designed for use with my clients. We use it for private schools, things like that. And you see here we have a risk assessment summary. And here, this means that the CNAC facilitators had to sit down as a group and think about what risks do we want parents to be thinking about when they send their kids to forest school. And forest school, for those you don't know, is basically school. It's usually some place. There's an elementary school that has forest school, or under age 5. It's kind of a daycare type situation where the kids are outside all day, no matter what the temperature. They have a yurt, they have a fire, but they're outside all day. So poison ivy. Don't come complain to us if your kids get poison ivy. We're gonna do our best, right? But your kid may run off in the bushes and get poison ivy just like he may or she may do at home. No difference, right? We've got wild animals and ticks. We could have some bad weather. I had a client email me just yesterday saying, hey, parents are complaining about the hot weather. Should I shut down? Right? So these are things that come up that you have to think about, and you have to at least inform, I suggest, the parents of what your plan is, right? Negligence. Now, we put this in here, and we actually had to take it out of the agreement when it came to one of the programs. The Carleton School Board was using the forest school, and they refused to include this. And I said, fine, take it out. It's not really that relevant what we're doing here, right? We're not worried about negligence here. We're worried about informed consent. So you can see here that you have the parent initial it, that they reviewed everything, they're aware of it, they freely voluntarily assume the risks of this. It reads a lot like a waiver, but it's, I think, different. I submit it's quite different. And I'm satisfied. I've read this. I'm gonna let my kid come to this program, right? And I know that I might have to let them know of a health condition so that they're not unaware my kid has asthma or a reaction to bee stings, for example. That's something that's on me. You see, they have to sign, etc. So that's just an example of how the informed consent can work. And you can plagiarize these forms. They're on the internet. No one's going to stop you. But what you should do is have your folks who run the programs think about it. Think about what should be in this form. Make sure it's tailored to your programs and to what you want the parents to know. Go back here. I hope I do this right. All right, so I'm back here on the presentation. And my point here is that the bottom point, it doesn't offend my conscience to sign an informed consent to send my kid to a camp versus a waiver or release that I know is not enforceable, but that has an indemnity that may be enforceable. And as a parent, that doesn't offend my conscience. Because when I send my kids away, I want to know the person organizing this particular activity has thought through these things. Now, if I go to a zip line, which I do with my kids, I also, I'm not as worried about myself as my kids. Maybe that seems a little ridiculous, but I have a similar view in my own heart about, okay, if this whole apparatus fails and my kid gets hurt, then I got a problem with that. But I've waived my rights. And maybe that doesn't make any sense, but I try to rationalize that as best I can. So then what should the community standard be if you're offering programs to kids? And should it differ for local governments as opposed to a zipline park operator? So when it comes to this whole area of risk, this last slide here gives you some tools. And there's a link here in the presentation that you can look at. But I was part of the Canadian Risk Assessment Committee for Outdoor Play. And what we did was we put together a toolkit that'll help you walk through as an organization how to put together your own informed consents and things of that nature. Particularly in a post-COVID environment, we know folks will be turning back to these things and revisiting how to deal with these things, particularly to include issues about how to deal with reopening facilities and all your programming without wearing masks, without social distancing. And I think you should look to CNAC because they're looking at that nationally as something that they want to help people work through. And I know I'm gonna have a lot of questions for myself as we go through this process as well, as to how we're gonna deal with these documents that parents typically sign. I wrote a lot of different documents during COVID that were waiver documents, informed consent documents, warning signs, you name it. And I think people are going to revisit that, hopefully coming out of this in a positive way. So I've gotten through everything that we had in the slides. We're just 2 minutes before noon, but I'm happy to stay a little bit longer. This is my kid outdoor climbing with a volunteer organization in British Columbia, actually in the Vancouver Island organization, the Alpine Club. And of course, I help them with their waivers too. So you can see my risk tolerance and how I view these things maybe differently than others. So I guess we should look at the chat, eh?
Yeah, so we did have a few questions throughout, Aaron, and the first one was from Vanessa. For e-waivers, does a digital signature make the form a binding contract?
The only case I'm aware of is the one that we found in Saskatchewan. But I can tell you that almost all of my clients are using e-waivers. Folks are doing a bit of a hybrid though too. They don't trust it. They're concerned about it. I'm not opposed to a full e-waiver system. I'm not opposed to a hybrid system. I do think it's important that you verify the identity of the person when they arrive at the activity to say, this is you sign this document. But as long as you have verified the identity, I think you're fine. I think it's pretty silly for a person to say, well, actually, I didn't sign it. It was somebody else. Well, that means you're trying to actually game the system. So that would be kind of ridiculous. So I do think these systems should be implemented and that they work. And I also appreciate that it saves us paper. It means they're easier to store versus having files and files of waivers that sit in someone's office, and they got to somehow pull out when something goes sideways.
Perfect. The next one was from Tim, and you kind of touched a bit about this, but maybe you have more about that. He had stated, I haven't heard this yet, but wondering if COVID/pandemic has influenced the crafting/wording of waivers, indemnities, or conditions of participation.
So one thing that we did was we looked at our existing waivers and we said, they're really broad. So we don't really want to undermine them by putting in more language. So a number of different forms of documents went out from various lawyers like myself. And essentially those forms would be particular to COVID. We did an informed consent model for municipalities for COVID, things like that. And then some places had a waiver, their normal waiver, and they had a separate waiver for COVID, so that they had all that in place. Some places put a line in their existing waivers for COVID, and presumably will take those lines out. There's no magic to this, is what I keep telling my clients. We don't know. But I will be the lawyer dealing with this if things go sideways, I suspect, because I already know clients have reached out to me about, if things go sideways, you're our defense lawyer. So far, we've had no instances of lawsuits to my knowledge over COVID in BC, as far as I got COVID at your, because of your bench at a park, which seems ridiculous, but that's another issue to discuss. So I don't think so, but the bottom line is folks tried all different kinds of models. I think they're all effective in their own way.
Perfect. Yeah, I think that's common. And then Shelley had written, so an issue in our community regarding new citizens who have immigrated to Canada and the sometimes lack of understanding of the English language of our participants. What is our duty of care in getting the message across in what could be numerous different languages?
That's a great question. I've never had that question posed to me. And I don't have a good answer off the top of my head. I think you're right. Obviously, someone can say, "Hey, I don't speak English," so I just nodded along and I signed this thing. It may be something that people have to consider, whether they have to have them in different languages. I can tell you, to my knowledge, none of the private operators are doing that. But it's something to consider. I think it's a very good question.
That's typical. Shelley brings up a good question. For those who know her. And then one other question here so far, how long should signed waivers be kept?
Well, I think they should be kept for obviously with infants, with people under 19, you got to keep whatever form they're utilizing until they're age 21 plus 2. So that's why the e-waiver system is such a better system, because it doesn't matter, keep them forever, right? With the written waivers, it gets a bit harder. So I think that's the problem. For adults, we know that if an incident occurs, they have, I think Saskatchewan's 2 years for limitation, I'm not sure, but they have a limitation period and then the claim is basically dead. For kids, it's 19 plus 2, and with COVID, at least in BC, that's plus 3. So I think that's something that folks should consider, keeping those documents for a very long time. As many as at least, I would suggest 20 years, right? So just think about that. It differs between parents, or between adults, and between infants.
Fair enough. And Aileen asks, any ideas or leadership on signage at unsupervised playgrounds used at your own risk spaces?
That goes back to my second slide about the warnings. I get a lot of questions about warning signs, and you saw the Duddle case with all the "don't dive" type signs. If there's an unreasonable risk of harm, then put up a warning sign. But I don't think use at your own risk does you any good, frankly. I think that if you say this place is not supervised, I've had people who operate campgrounds, and they'll put up signs that say, "We do not monitor this camp site." In other words, if you see something, let us know. We're not driving around every 15 minutes trying to find a piece of wood that fell down, or a tree that might be coming down. So I think you have to decide which ones are unreasonable risks to warn about. We've looked at, for example, in trails, recreational trails, about whether we put up signs that say, we don't remove trees, right? We don't inspect the trees. These types of things are becoming issues that I think are really hard to grapple with. And again, I see no magic here in signage.
I think that's all the questions in the chat. If anyone has any more. If not, Guy, I'll let you take over.
Let's unmute that to start. All right, so seeing no more questions, thank you so much, Aron and Megan, for sharing this valuable information with our members today. If any of you have or wish to receive a certificate for attending today's webinar, please send me an email. I know others have asked for them in the past. A recording of today's session will be posted on our website as we did with Aron last year. So all the information that he shared today, all the questions and the answers, you can go back to it at your own time and your own leisure. So thank you for attending our session, everybody, and have a great week and stay cool.